Mike, what's your prediction on what the Supreme Court's likely to do on these rulings out of Colorado and Maine?
So I think the Supreme Court will take this case quickly, even though these cases are stayed by the Colorado Supreme Court. Once Trump filed his appeal, the Colorado Supreme Court said we're going to stay the decision and go ahead and put them on the primary ballot. Same in Maine. The reason the Supreme Court needs to take this case is because this bad precedent in Colorado with the four wacky Democrat-appointed Supreme Court justices and this 4-3 ruling in this, like you said, unelected, non-lawyer, wacky Maine Democrat Secretary of State who thinks that they just get to decide for millions of voters who's on the primary ballot. That is a terrible precedent, and that needs to be nipped in the bud immediately so it doesn't get used in other states. If the only way you can disqualify under Section 3 of the 14th Amendment passed after the Civil War to chase out of office insurrectionists, Confederate insurrectionists who engaged in insurrection or rebellion during the Civil War. The only way you can disqualify, and there's a case from like 1869 on this from Chief Justice Salmon Chase, is Congress has to pass a federal criminal statute. You have to bring federal criminal charges for insurrection or rebellion. The grand jury has to indict. The jury has to find the defendant guilty with evidence beyond a reasonable doubt, unanimously guilty. The federal judge has to convict under this specific federal criminal statute for insurrection or rebellion, and then that conviction must be upheld on appeal. That is the only way you can disqualify. You can't have partisan judges on a state Supreme Court with an expedited election challenge proceeding where you don't have due process, where you're letting in boatloads of hearsay evidence. You don't have a fair trial, or you especially don't let an unelected, non-lawyer judge just decree that there's an insurrection and take someone off the ballot.
The thing in Maine is really, I realize that the Colorado case being appealed to SCOTUS is in its own lane. But the thing in Maine, Dave, is really outrageous. Like some non-lawyer Secretary of State is like, she's appointed, not elected, is like, feels very insurrection-y. Really insurrection-y to me, so he's off. Yeah, he's not going to be able to run for president in Maine. Come on, even you have to see that is fraught with peril.
Well, first off, it's great to be back with you, Megyn, and my friend Mike. I'll say this. Last time I was on, I said that the Supreme Court is going to overturn any ruling that kicks Trump off the ballot. So I'm in agreement that the Supreme Court is going to overturn Colorado and Maine. But I must say that I think what we've seen in Colorado and Maine is exactly how the process is supposed to work, where the states are in charge of administering elections. It's in the Constitution, and they interpret this clause that is somewhat vague in the 14th Amendment that is rarely used. And in Colorado, although Mike will say they're wacky justices, the three justices that dissented, that ruled for Trump, were also appointed by Democrats. But in Maine, it's true, it's not an elected official, but that's state law. That's how it works. And the state law then goes to the U.S. Supreme Court to determine whether it is constitutional. I think the Supreme Court is going to overturn it based on due process grounds. They may latch onto that Chief Justice Salmon Chase's opinion that Mike Davis refers to, although I must add that Salmon Chase reversed himself when it came to the case of Jefferson Davis. When he had to lead the trial of Jefferson Davis, he said that the 14th Amendment was self-executing. So he reversed himself on that. But in the end, I do think the High Court is going to rule that Congress needs to act. You can't have 50 different states acting in 50 different ways, perhaps with partisan bents and going after your political enemies. And so let's have Congress rule. By the way, on that note, Section 5 does give Congress the power to enforce the 14th Amendment, but it does not give Congress the power to exclusively enforce it, which is why states like Maine and Colorado can do this.
Wait, we're losing people. Let's make it simple, because most people are not studying this clause of the 14th Amendment day to day. But essentially, the argument is that the 14th Amendment has a prohibition against insurrectionists from holding federal office. If you swore an oath to support the Constitution and then you engaged in an insurrection, you can be banned from federal office. And one of the questions that's being raised in this is that clause, as you point out, self-executing? Or do you need, as Mike is saying, Congress to pass a law and more due process for the alleged insurrectionist? Or can it just be like, we can all see you were insurrectiony and it's self-executing, and therefore I don't have to get any official body other than me, the Secretary of State, to say you did it? Well, here's what Trump is arguing before SCOTUS, and I'd love to get your take on this. They say, all right, first of all, they point out that the two-sentence clause in the 14th Amendment says anyone who swore an oath to support the Constitution and then engaged in insurrection cannot hold office unless a 2/3 vote of Congress allows it. That's them saying you got to have Congress. It's not self-executing. Then they argue that this provision is not intended to apply to the presidency. Now, we've heard this from Team Trump and their surrogates before, that this really only applies to lower officials, not to the president. And they say, this is kind of, I thought, to me, this was a new one. They say the oath for the presidency, by the way, is not even to, quote, support the Constitution. It is to, quote, preserve, protect, and defend it. Now, we've all heard that on various TV shows, right, where they show you the president swearing in, preserve, protect, and defend the Constitution. It's true the word support is not in there, though, seems like preserving and protecting and defending it would be to support it. They also argue that the presidency is not explicitly mentioned in the amendment, only, quote, an officer of the United States. They say that's a legal term that does not apply to the president. However, when Trump was dealing with the Manhattan DA's office in this, Stormy Daniels hush money case, he argued that this case should be moved to federal court because the president is, quote, an officer of the United States. So he argued something different in the Manhattan trial court than he's arguing to the Supreme Court about whether the president is, quote, an officer of the United States. So let me give you a crack at that one first, Mike, since you're more in the defense of Trump place.
Well, I mean, that's an open question. It hasn't been decided, but there are people, including the Denver District Court judge in this case, this biased Denver District Court judge who, she was judicially biased. She donated to an anti-Trump January 6th PAC to chase Republicans out of office, and then she sat on the anti-Trump January 6th trial to chase Trump out of office. So I don't know how she was able to do that. She said she could be fair, but regardless, even that judge, even that Democrat-appointed judge in Colorado, said that the 14th Amendment does not apply to the President of the United States because he's not an officer of the United States under the 14th Amendment. There are scholars on both sides of that. I would say this, it's an important argument, and maybe the Supreme Court will ultimately have to decide that if the Supreme Court finds that there is an insurrection, finds that Trump incited that insurrection, and finds that the Maine Secretary of State can unilaterally disqualify him or the Colorado Supreme Court can disqualify him. I don't think the Supreme Court will have to decide that question because they can decide on narrower grounds where they don't have to decide the constitutional question.
Like what? What do you think they're going to say?
Well, I think the Supreme Court could say very easily that, hey, if you want to disqualify, it has to be through a federal criminal statute. And Jack Smith and, January 6 Democrats who spent tens of millions of dollars hunting for evidence of insurrection could not find evidence of insurrection because Jack Smith did not charge Trump with insurrection or rebellion under that federal criminal statute. And think about it this way. January 6th was a lawful protest that permitted by the National Park Service that devolved into a riot. And how many insurrectionists go unarmed into a nation's capital, walk through velvet ropes, follow police direction, take selfies on the Senate floor, and don't burn down the damn place?
It can't be. He's raising a good point, Dave, about how there's been no finding of insurrection. He hasn't been charged with insurrection by Jack Smith. It's really like a gut feeling. It feels insurrection-y. How can that be enough to ban a presidential candidate from a ballot?
Megyn, the wording of the 14th Amendment does not require a charge or a conviction for insurrection. It's just, did you engage in insurrection or provide aid or comfort to one? And here, Trump, you could make the case that he engaged in insurrection and provided comfort to the insurrectionists, even if no one is ever charged. And that's why it needs to go through the courts. And that's why the Colorado courts were right to at least examine the issue. And I thought they had a pretty well-reasoned 133-page opinion. And in Maine, this is the calculation that they're making. And so I agree with Mike, though, that I don't think you need to go to whether the president is covered under the 14th Amendment to overturn it. I think it's going to be overturned on procedural grounds, on due process grounds.
Negative dings on credit reports happen to all sorts of people from all socioeconomic backgrounds. Understanding the credit landscape can be extremely tough, and spending the time to dispute and repair these so-called dings can be a full-time job. Good luck to you if you already have one of those, or kids, or anything going on. For starters, you have to deal with 3 separate credit bureaus, which no one wants to do. It's also a common misconception that people with poor credit scores are just people who don't pay their credit card bills. They just simply don't want to do it. These actually can be hardworking folks who are negatively affected by divorce, identity theft, medical debt, student loans, or they just don't have the time or are too overwhelmed to fix it. But if you do not address negative credit items, they can haunt you for years to come. And when it counts the most, like when you're trying to get a mortgage at a competitive rate. The good news is our sponsor, Lexington Law, would like to help you. Go to lexingtonlaw.com and start today with a free consultation and review. Tell them Megyn sent you at lexingtonlaw.com. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.